I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame. Today, I am bringing you our 28th compilation. That's right. You heard it right. This is our 28th one of some classic moments from here on the channel. Before I give you the judge's rundown, just know there will be no commentary. Chapters will be added, so you can jump around if you've seen one of these and you don't want to see it again. But if it's a oldie but goodie, hey, feel free to watch it again. But the four judges courtrooms we will be in on today will be Judge Mara Rozanno out of the state of Washington, Judge Rochon also out of the state of Washington. Third, we will be in the courtroom of Judge Lisa Martin out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Joseph Slaven, also out of the state of Michigan. With that being said, guys, I am having a lot of fun here with you guys on the channel. Your interaction with the channel and me has been amazing. Keep up the great work. And with that being said, guys, let's go ahead and jump into these proceedings.
All right, it's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me?
Yeah, hold on one second.
All right, good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with a case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please tell me? Well,
I'm here physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
I don't even consent to that.
I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
then what am I doing here then? Hold on, what am I doing here?
Well, right now you are not responding to my questions. So
well,
I'm
you're not
going to have you
responding to any of my. I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything. I'm not perfect.
I'm in person so that we can be sure that you understand what's going on.
All right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
Your Honor, next we can take Aaron Thomas.
Okay.
And Your Honor, after speaking with Mr. Thomas, he was not comfortable with me signing the rights form on his behalf, and he would like to have an arraignment in person.
And that's fine. Can you hear us all right, Mr. Thomas?
Yes, sir.
All right, very good. This is 3A757954 and 3A757955. When can we arraign him in person, please, Carrie?
Your Honor, due to the holiday schedule, the earliest would be December 7th at 2:30.
Okay, Mr. Thomas, write down December 7 at 2:30 and confirm when you've done that.
Okay. 1 second here.
No problem.
Yeah, I got my phone stolen last night, so I gotta do it on my computer here.
Yeah, no problem. Just let me know when you got that in there.
All right.
Did you get it in there?
Not quite yet. I'm opening up a
Okay.
note.
Just let me know.
Thank you, sir. Okay, you said December 7th at 2:30, correct?
Right.
All right, I got you.
And it's here at the Bothell Municipal Court, Mr. Thomas.
Okay, thanks. All right, yeah, I got it down.
Thanks so much for writing that down. And keep that, don't erase that. That's your notice now. You got an actual notice, right?
Well, oh yeah, I mean, I have it on my computer here.
Fantastic. Thank you, sir.
Hey, I hope you have a good day.
The court's found probable cause for the prosecution is charged, so subject to you and your lawyer readdressing this, you to be here on time for all scheduled hearings, commit no criminal acts, don't drive until you have valid license and insurance in your pocket. Any questions about all that?
No, I wasn't driving though.
Good. Please don't unless you have license and insurance in your pocket.
I would
Right.
never drive. Yeah, I would never drive.
That's fantastic. Glad to hear it. Thank you, sir.
You're welcome.
All right. Next case.
Okay, cool. Have a good day.
You too.
Mr. Frank Michaud, who is present here on Zoom. Mr. Michaud, can you state your name for the record?
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
Mr. Mohammed.
Good morning, Your Honor.
Good morning. My apologies for interrupting your breakout, but I want to get some of the matters that are already on screen and ready cleared out. Mr. Sullivan and Mr. Moshu.
Ready?
Thank you. Today is the day and time set for the probable cause conference. How are we proceeding, Mr. Sullivan?
Judge, as I was saying earlier, Mr. Michaud has indicated that he'd like to represent himself. Hopefully, if it's acceptable to him, I can remain just sort of present for the proceedings in case he has any questions. My recommendation to him is that we demand all of the discovery in the case. We have paper discovery. I'm forwarding that to him, but we don't have any of the digital discovery. So we are requesting all of that. And then I'm also recommending to Mr. Michaud that we schedule the case for a preliminary exam. And I'm happy to be present for that as well.
Mr. Mohammed?
Yeah, Judge. So I don't believe we had an attorney on record on file for this case. And that's probably why discovery wasn't sent over. Also, I believe we're missing some stuff as well, and we're in the process of getting them as well. If Mr. Sullivan's going to be the attorney moving forward, we'll send it to him. But if he's no longer going to be retained, then I don't know. I don't think it's useful to send it over to him. So if we can know who the attorney is moving forward, we'll send that discovery to that attorney.
Mr. Sullivan, are you formally making a request to withdraw from this case?
Judge, maybe my request is that we have an adjourned PCC for me to meet with Mr. Michaud and discuss this further, unless he'd like to make a decision just here and now. Perhaps one adjourned PCC and some additional time for Mr. Michaud and I to discuss this. We can come up with an arrangement where I'm at least receiving the discovery, on his behalf and trying to facilitate this for him. But I do want to respect his desires to represent himself.
And Judge, the people would have no objection to any adjournment. And if Mr. Sullivan is the attorney moving forward, please just send me an email letting me know, so that way I can make sure digital is sent to you.
Mr. Michaud, were you able to hear Mr. Sullivan just now?
Yes, ma'am. I heard everything that was said.
And was that a reasonable way to proceed at this time? I'm sorry.
Oh no, and I still stand as being the beneficiary of the estate and point you as trustee, and demand that this alleged debt, is discharged from my account, from my exemption account. As I sent over copies of my birth certificate, as well as an affidavit. I don't know if you received it, but it's been sent certified mail. And that is me standing as making this special appearance today. And with the challenge of the jurisdiction, since I have not really been fully told, or I really don't understand really the allegations or the nature and causes of this allegations on my estate.
Sir, I'll interrupt you just for a moment. In as much as you've indicated that you don't understand or have not been fully apprised of the nature of the allegations, we will adjourn this matter over for 3 weeks. That adjourned PCC date will be
December 20th at 8:45 with Judge Oakley.
the adjourned PCC date will be December 20th, 2023 at 8:45 a.m. That's in person in courtroom number 2 with Chief Judge Brian Oakley. And between now and then, Mr. Sullivan, you have the opportunity to speak with your client, bring him up to date on the status of these matters and explanation of the charges against him. And if you want to, at that time, have a conversation with Judge Oakley about how you be proceeding or not proceeding as counsel, that would be the time to do it. Is there anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Sullivan?
Judge, I apologize for the inconvenience, but I am in a sentencing that morning of the 20th. I don't know if does the court have availability like later in the morning. I could make it work late morning on the 20th or in the afternoon on the 20th.
10:45.
That'd be much better. Thank you very much.
Thank you. 10:45 on December 20th. That concludes this matter. You're free to go. You have a good afternoon.
Ms. Sobe, you're here on the Martin matter, correct?
Yes, Judge.
Let's go have a conversation outside.
He'll be okay, so everyone,
all right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
yes, good morning, Judge Donna Sobe on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I'm making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I could adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements. You're talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything and you keep doing all your little negative comments, things that you want to say about people. And you think you're the smartest person in the room and that you have some sort of special Juris Doctorate, I guess, from somewhere. I don't know. But you don't have the first clue when it comes to things. And you talk about that. And so Mr. Gizicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want, all I asked you was this. I didn't ask you to give me a commentary about Mr. Gizicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I don't want to state also that if it was recorded, that we would state it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. Which is what is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like. Or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without
all right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. Well, I don't say for the most part, maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slaven, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.